Ladies and gentlemen, it is a real honor and a great pleasure to join you today at this 8th annual conference of the Refugee Law Initiative. I know that we've had a very long day of debates and discussions already, and the last thing you probably really want is a 30-minute monologue on my part. But please do bear with me because I do have some fairly important points that I would like you to consider. So this week we've gathered to discuss the theme of facts, promises, and refugee protection. It's great to see that the conference program proceeds discussions which will explore the intersections of law, policy, and the lived experiences of refugees worldwide. I am particularly grateful for the role that academia plays in advancing knowledge, engagement, and respect for rights in refugee law, forced displacement, and migration. Many of you are actively engaged in teaching and building knowledge on key principles, in rigorous and ethical research, which increasingly and extremely positively involves refugees as leaders and experts, and in advocating for rights-based policies. I am really honored, alongside other UNHCR colleagues present throughout this conference, to speak to this essential topic and, more importantly, to hear and learn from you all. Today I will discuss how the Global Compact on Refugees, the GCR, built on foundational legal principles, including the 51 Refugee Convention and international human rights law, has reinforced and operationalized these principles to meet contemporary challenges in novel ways. In doing so, I will highlight some of the GCR's concrete impacts and further potential to facilitate protection and solutions to forced displacement. I will highlight some of the Compact's important innovations, including those emerging from last December's Global Refugee Forum, the GRF, while seeking to address some of the valid questions which have been raised by some critics, and recognizing how much work still needs to be done. I will conclude with a call to action to all of us to redouble our efforts to promote respect for crucial legal principles and access to rights for refugees in the current challenging political context. We are all acutely aware of the significant and unprecedented challenges facing international refugee protection today. These include the vast scale of displacement in many parts of the world, with refugee numbers doubling since the New York Declaration in 2016. Yet, responsibility sharing remains alarmingly uneven. 3 out of every 4 refugees are hosted in low and middle-income countries near their countries of origin. We are also witnessing a troubling erosion of respect for international legal standards, including, but not limited to, international refugee law. Breaches of international humanitarian law in recent months have been particularly egregious. We have observed some states taking restrictive approaches to international protection criteria, or implementing, or trying to implement, unlawful externalization policies, involving attempts to shift responsibility for their protection obligations to other states. UNHCR and many others also continue to document pushback and removal practices worldwide. These repeated breaches of a cardinal principle of international refugee law are a matter of serious concern. In mixed movements, we also often see particular obstacles to protection. Many refugees move alongside migrants, using dangerous irregular routes in the absence of legal pathways. We see people resorting to asylum channels, including many without a basis for their claims, as the only available means of lawful stay. This means challenges for states as well as for individuals, as this congests asylum systems and creates delays for refugees waiting to have their status determined. In turn, this can negatively impact the credibility of asylum systems and public and political support for refugees as well as for migrants. Other practical and operational challenges to refugee protection include obstacles hindering humanitarian access to those in need of protection and assistance. Worldwide, we also see dwindling humanitarian funding, leaving protection and assistance massively underfunded in many situations. This is notably evident for the so-called forgotten emergencies, which are not in the media headlines. As a stark example, as of the end of last month, the refugee response plan for Sudan was funded at only 8%, and the humanitarian response plan funded at 15%. Adding to the complexity of movements both within and across borders, climate change impacts are also increasingly contributing to displacement. To address these multifaceted challenges, we need new tools anchored in principles which can effectively be implemented in practice To this end, the GCR articulates and revalidates key legal standards and offers a relevant framework for action today. The GCR is built on the foundation of enduring principles of international refugee law, particularly the 1951 Convention and its 67 Protocol. The compact itself was never designed to formulate new binding standards. However, its affirmation by the UN General Assembly in 2018 was a renewed expression of states' commitments to existing standards under international law, and a reaffirmation of established rights and obligations. The GCR also aims to encourage and enable states to uphold these standards more effectively and to take concrete action to enhance their implementation. Another key objective of the GCR was to address a long-standing gap in the international refugee protection regime regarding responsibility sharing. As we know well, the 51 Convention in its preamble indeed highlighted the need for international cooperation, but it did not articulate how states could or should work together in the coordinated manner required to ensure effective protection solutions and humanitarian responses. This has been referred to as a perennial gap in the Convention. So the GCR was drafted with the aim of addressing this perennial gap and of strengthening international responses to forced displacement. This would occur through better and more systematized coordination, expanded partnerships, more equitable burden sharing, and reinforced support to host countries. The Compact, through its 4 objectives, seeks to address a number of essential challenges. First, it seeks to expand solutions for refugees, which, given the current protracted displacement, is urgently needed. This includes solutions in third countries through resettlement and legal pathways, voluntary repatriation with safety and dignity to countries of origin, as well as local integration in countries of asylum. The importance of this has also been recognized by UNHCR's Executive Committee, which this year is working on a new conclusion on durable solutions and complementary pathways, drawing on the GCR and thereby translating some of its key objectives into a soft law instrument. Second, the Compact seeks to ease pressures on host countries while enhancing refugee protection and self-reliance by way of strengthened inclusion in national systems, including documentation, education, health, and access to jobs and livelihoods. Third, it enshrines a multi-stakeholder approach which acknowledges and creates space for other actors to contribute to more comprehensive refugee responses. The aim of this is not for non-state partners to assume the functions and duties of states, but to encourage them to complement, to support, and where necessary, to advocate and push states to respect their obligations. Last, and perhaps most importantly, the GCR both promotes access to rights and facilitates the enabling conditions needed for the realization of these rights by making host countries the center of gravity. The most recent GCR indicator report, issued in late 2023, shows us that there are clear examples of sustained progress across the 4 GCR objectives, such as assisting low-income refugee hosting countries, and increasing refugees' access to education, socioeconomic inclusion, resettlement and complementary pathways. While more needs to be done, this progress is significant and welcome. Against this background, let us consider concretely how the Compact has been implemented in innovative ways and what impact it has had in practice, where it matters, meaning in terms of improving the lives and enjoyment of rights of refugees worldwide. One central innovation is the mechanism of the Global Refugee Forum, the GRF, first convened in 2019 and again in December last year. While the second GRF came at a moment when the world seemed to be beset by even more crises, with escalating conflicts and climate pressures, economic challenges, and threats to human rights, it was a success, both in terms of the pledges made, but also in terms of the richness and diversity of participation. Speaking frankly, we feared that discord amongst the international community might deter meaningful engagement, pledging, and participation. But instead, we saw states come together at the forum with more than 420 non-state entities and over 300 refugees, an example of what our High Commissioner has called a new multilateralism in the making. Among the Compact's other novel features, the multi-stakeholder approach, and in that connection, the numerous multi-stakeholder pledges made at the last GRF, have brought new contributions and energy to protection and support to refugees. These complement host governments' policies and donor governments' contributions. I would like to emphasize one such pledge which would certainly resonate with all of you, the GRF Legal Community Pledge. Following the first GRF, this pledge unlocked more than 585,000 hours of pro bono legal support to refugees, including from over 100 private firms. Under the coordination of PILNet, hundreds of legal practitioners dedicated their time and resources to ensuring that refugees take full advantage of the right to seek international protection. Building on this success, the updated Global Legal Community Pledge has set a new goal of providing 1 million hours of legal assistance to refugees and asylum seekers over the period of 4 years. This ambitious yet achievable goal would not be possible without mobilizing power of the multi-stakeholder pledge process. You will hear more about these efforts during tomorrow's panel discussion led by UNHCR on law and policy in the GCR and GRF. Ladies and gentlemen, the work of the global legal community is further reinforced by the work of the Asylum Capacity Support Group, a GCR initiative that was launched in 2019 to support states in building up their asylum systems by strengthening institutional capacities, promoting legislation to facilitate asylum processing, and modernizing case management systems, mainly through matching asylum capacity requests with technical, material, or financial support. This work has already seen significant success. As one example, between 2018 and 2022, Mexico was able to increase its asylum capacity by an astonishing 438%, supported by Canada and the United States, as part of the Asylum Capacity Support Group pledge. On the operational level, situation-specific GCR support platforms mobilize and focus attention and support for key refugee situations. These enable a more efficient, predictable, and comprehensive response to displacement crises by bringing together countries of origin, host countries, and donors, together with development actors. These include, amongst others, the Solution Strategy for Afghan Refugees, the SSAR, the MIRPS in Latin America, the IGAD-led support platform for refugees in the Eastern Horn of Africa, and the Central African Republic Solution Support Platform. These platforms have facilitated tangible improvements in the delivery of humanitarian aid and access to rights in their regions. To illustrate this, between 2022 and 2023, the MIRP support platform helped direct $192 million from the United States to displacement responses in Central America and Mexico. Through the SSAR support platform, the core group in Pakistan advocated for and financed the document renewal and ID verification exercise in Pakistan, offering some 1.3 million Afghan refugees new identity cards. Most recently, UNHCR collaborated with the IGAD support platform to launch the IGAD Policy Framework on Refugee Protection, which establishes priority areas, key actions, and responsible parties on a range of topics, including access to territory, protection, and identity documents. The GCR has also enabled us to respond to several emerging operational and protection challenges. One, the route-based approach. Building on the complementarity between the two compacts, the GCR and the Global Compact on Migration, the route-based approach promoted by UNHCR and IOM has been developed to address the complexity of rights protection and human mobility in our current landscape, and to facilitate access to protection at an early stage of the journey, to reduce the compulsion to dangerous onward movements. Second, climate action. For the first time in a UN General Assembly resolution on refugees, the GCR recognizes the intersection between climate impacts and factors giving rise to international protection needs, namely persecution, conflict, and serious human rights violations. UNHCR has issued guidance on the need to apply more broadly and systematically the existing international protection criteria under refugee and human rights law as relevant. It is important to recognize also that some of those on the move, because of disaster and climate change impacts, are not in need of international protection. We need more effective international responses in climate-impacted contexts to address the challenge of ensuring respect for the human rights of all. Ladies and gentlemen, with significantly upscaled efforts towards broadening the base of support, the GCR has promoted a whole-of-society approach which reinforces the importance of states, but also non-state actors working together to advance refugees' rights. Allow me to reflect on this truly innovative aspect of the Compact and how it has mobilized states and others in novel ways. As we all know, states have the primary obligation to ensure access to rights. States have been mobilized pursuant to the Compact to pledge to accede or lift reservations to international refugee law instruments, adopt laws reflecting international standards, and work together to build protection and asylum capacity. And we are seeing in real time how these measures can push and enable states to meet their obligations. Regional organizations such as the League of Arab States and the East African Community have also played a key role in enhancing regional cooperation, dialogue, and response around specific refugee situations. UN agencies, development actors, international financial institutions, and other sources of financial and technical support help those countries to meet their obligations to refugees and the communities that host them. During the GRF last year, 32 UN organizations and 50 UN country teams came together around the UN Common Pledge 2.0, committing to support refugee-hosting countries with the inclusion of refugees in national and UN plans, budgets, and service delivery systems, such as education, health, water and sanitation, housing and social protection, as well as access to decent work. In the Americas, the Inter-American Development Bank launched a $100 million fund for displacement response, coordinated through the MIRP support platform, of which $40 million have been allocated in the last few years for 6 projects. Civil society, academia, religious groups, municipalities, the private sector, and other key actors also make a significant contribution. They highlight the social benefits and contributions of refugees and promote the legal and moral obligation to protect and include refugees. Some specific examples of this include, through the pledge of the Global Alliance of National Human Rights Institutions, some 120 national human rights institutions have committed to implementing national initiatives to promote greater human rights protection for displaced and status persons, in line with their unique mandates and functions under the Paris Principles. And academics have also made and fulfilled 2 broad categories of pledges. One, through scholarships and university places. Many universities are now enabling refugees to access education, which equip them and their communities with the means to exercise their rights. 2, carrying out ethical research that includes refugees, raising awareness, and providing the basis for evidence-based advocacy and policy making. Finally, and perhaps most importantly, the GCR has increased and deepened the meaningful participation of refugees and status persons themselves at multiple levels. This, in turn, has the potential to curtail divisive rhetoric against refugees. As I mentioned previously, the GRF in 2023 saw more than 300 refugees taking part, including as part of 14 state delegations. There is no other multilateral forum where refugees are involved and present in such a concrete and effective way, addressing heads of state and others directly, but also in the conceptualizing, developing of pledges and in advocacy for their fulfillment. Ladies and gentlemen, notwithstanding the positive achievements so far, we are far from the level of responsibility sharing and access to rights at which we need to be. Much needs to be done. The Compact is judged by its results on the ground through the GCR indicator framework. The GCR indicator report acknowledges that progress, while significant, is still insufficient. For example, quite powerfully, data shows that in 2022, new displacement continued to outpace available solutions. Host countries of large refugee populations have voiced frustration at what they see as the international community's failure to deliver on its promises. While the total volume of official development assistance allocated to refugee situations in developing countries remains significant, some $26 billion, it is unevenly distributed across refugee situations. And while many of those countries have committed to law and policy measures, giving refugees more access to work, freedom of movement, and inclusion in national education systems, these commitments need to be matched by commensurate support by donors, so that they can be translated into practice and real impact on the ground. In the face of many violations and breaches of international law, we need to maintain our collective efforts as organizations, lawyers, and advocates to bring attention to these violations and, where relevant, to hold states accountable, including in the courts. In considering the impact so far in terms of practical concrete applications of the compact and its potential moving forward, it is important to recall that the GCR is an expression of political will by states to respect their obligations. The challenge is, of course, to ensure that we can move beyond the commitments on paper to acts which can ensure the fulfillment of the rights of refugees worldwide. We see several important ways in which we can continue to further enhance the positive impact of the GCR. First, in today's challenging global context, we must leverage all the tools at our disposal, including the GCR, to urge states to strengthen their laws and policies in line with the obligations outlined in the 51 Convention. We can sign and draw upon the compact in national, regional, and international fora as a basis for a wide range of partners to mobilize and rally support for the fulfillment of commitment by states. As I pointed out, the compact does not replace or diminish the obligations set forth in the Convention, but complements and reinforces them. We can also use it to garner support from donors and other stakeholders to enable these to be translated into practice. The GCR can advance access to rights and broaden the base of actors who are working to advance those rights. Second, we should consider how the compact can inform and guide responses to displacement situations in ways which can highlight its utility and build its authority. For this, there may be scope to follow the example of the guiding principles on internal displacement, a non-binding framework which has nevertheless developed into a major authoritative text that is widely respected and used. Third, there are ways to use the compact as an instrument for accountability and an incentive for action through the regular follow-up and review processes it foresees, such as the GCR indicator report and the GRF pledge mobilization and implementing arrangements. These can also contribute to the effective capturing and analysis of data on refugees to help measure progress and gaps, notably on access to rights. Academia has a unique role to play here. Fourth, we can all contribute to advancing the objectives of the compact to achieve better protection for refugees through pledging, whether to support state capacity on asylum through developing guidance, to contribute to knowledge and evidence on refugee situations through academic research and data, or to support refugees directly through legal advice. Finally, an additional concrete priority area for engagement I would like to raise is statelessness. As we mark the 70th anniversary of the adoption of the 1954 Convention on the Status of Stateless Persons, and the 10th year since the launch of the I Belong campaign. As part of the forthcoming Executive Committee meeting in October, a high-level segment on statelessness will be held as a multilateral movement to mobilize the world's attention on statelessness, to celebrate progress, and to renew commitments through concrete pledges. I would encourage all of you to engage and advocate on the pressing nature of this challenge and the importance of guaranteeing the right to nationality in your capacities as legal experts. Ladies and gentlemen, as we have seen, the compact complements and reinforces the Convention by placing rights at the center of responses to refugees. As we navigate an increasingly complex global context, leveraging the GCR as a fundamental legal instrument, as well as an advocacy tool and accountability mechanism, is absolutely vital. We must use the compact to push for stronger laws, policies, and practical measures that uphold refugees' rights. I look forward to hearing from you about your perspectives on the compact, including how we can collectively continue to advance the goal of upholding and elevating standards of protection for refugees worldwide. Thank you.